Good morning, everybody. We're going to take a peek at what's happening with the Murdaugh live hearing today. Bulletin. Let's see what they have to say. I hope everybody had a good weekend. So much going on. It's hard to break it down into pieces, right? Too much. But it's Monday. And we're going to make the best of it. Yeah, everybody's muted. They haven't started yet. Everything is on island time, so they take their time. Let me see if I see any faces. Who is that in the red jacket? Puppies are asleep, so it's going to be a quiet one. Hopefully a short one too. I have a lot of work to do. I'm prepping a couple of other things, starting with a recent finding that I want to share on the Celebrate portion of it. There's a lot of fuss out there in regards to digital forensics and how it's being handled. So I've been working on something in regards to that. I also watched Rachel Rolling's interview Saturday at 3:00, and it was pretty interesting. But I have something else prepared for that. Let's see. It looks like we're about to start. I'm not happy about this, but this is how it should be. If something happened that tainted the decision, or is proven that there was a clerk who interfered with the transparency and the integrity of the trial, this is what should happen. So it's a waste of money, but we will see what happens. They're all getting settled. I'm going to see if somebody else has audio by mistake, which I doubt. But I'm going to take a quick peek and see. Local stations maybe have a better angle, or I'm going to see. No. Nope. There's also a trial in New Jersey that I want to take a look at, because that person, his wife. Oh, here we go.
Back in court in South Carolina. It's his first appearance since the state Supreme Court overturned his conviction for killing his wife and son. Skylar Henry has more.
Mr. Murdaugh, I sentence you to the State Department of Corrections.
Alec Murdaugh is back in the courtroom. once again facing the same murder charges that put him behind bars more than 2 years ago. In 2023, a jury found the prominent South Carolina attorney guilty of murdering his son Paul and wife Maggie and sentenced Alec to life in prison. But just last month, those murder charges were overturned and a new trial was ordered by the state Supreme Court after it ruled that a court clerk at the time, Rebecca Hill, who went on to release a book about the trial just 4 months after the verdict, had tampered with the jury. For Murdaugh's second murder trial will be very different from the first one. Prosecution is not allowed to use evidence related to Murdaugh's convictions for financial crimes. He was already sentenced to more than 60 years in prison.
In the first trial, the prosecution presented that debt that he had racked up as a real motivation for the potential or for the alleged murders.
The defense is also requesting access to new evidence, DNA that was found under the fingernails of Alec Murdaugh's wife, Maggie. CBS News legal contributor Caroline Polisi says that indicates what the defense strategy may be.
It could be that they put forth an alternative killer allegation, or that they might point the finger at somebody else. So I think this trial is going to look a lot different from the first trial.
And so, as we'll learn more later today, Murdaugh's attorneys are also asking for a change of venue given the publicity of this case. As for Murdaugh, he will remain in prison here in South Carolina, serving out that decades-long sentence for those financial crimes. Nate?
Skylar, thank you.
Yeah. Yep. Still nothing. Still nothing. So the financial crimes are not going to be discussed this time around. He's already been charged for those. So, and even if anything is to happen, he's got 60 years. He's looking at 60 years just because of the financial crimes. It's amazing what people are capable to do when nobody's watching, huh? Like, and that should be the entire concept behind integrity. Do the right thing when nobody's watching. That's what Proctor said, remember? But it's just, why is it so difficult? Is it greed? Is it, the thirst for power and control? Why? I mean, it's just bad. I stumbled into a short clip, and this is 1, 2, 3. I think it was like 4 or 5 lawyers that were sitting together. It looked like a hotel room on a table, just bouncing ideas back and forth in regards to Karen Reed. It's the first time that I see this show. I don't know, maybe it was because it was Karen Reed related and it popped on my thing. But, you get out of the state and you get lawyers and everybody pretty much coincides on everything that is like basics of the law, right? Like lawyer 101. But when you see groups of lawyers from other states that are not necessarily 100% familiar with a specific case, it's refreshing to know that they don't know details. And when you throw a detail here and there, they go, what? And they're like surprised, like in shock. What do you mean? And then you throw them a link. Well, watch this. Well, but, and then they did this. Yeah, but there was a hostage video before the trials. And they go, what? And then you share the link. And then they go, who did this? That's the district attorney for the county. What? So it tells you that, when you lack of every single detail and a lot of information, you can issue a neutral comment, perception, opinion, but it's not necessarily tied to the entire whole enchilada sort of truth, right? So that was kind of funny to see. I ended up sending them links of a bunch of other stuff and defamation lawsuit, and hoping that, they also jump the boat and start talking about it. The more people that talk about it, the better. It's like, I really get pissed off when I hear that, Total Boy tainted the jury, the lawyers tainted the jury. The first person who tainted the jury was Michael Morrissey with that video. He reached an unmeasurable audience in Massachusetts. He pretty much told the entire state, right? Anybody who watched him live, watched him later, or picked up a newspaper, he told everybody that the witnesses who were supposed to be looked at as suspects at that point were innocent, and that the innocent was guilty before proven guilty in a court of law. So, like, who does that? That is a violation of the rule 3.6 or 3.8, whatever the ethics violation the ruling is in Massachusetts. It's a federal law. You can't do that. How do you go in front of a camera and tell everybody and their mother in a whole state that a Boston cop was killed, and there's 11 people who spent the last 40, 30, 15, 10 minutes with him, and they are all innocent? But Karen Reed hit him with a car. To get away with that, you have to have an extreme amount of control and power. To deceive the public like that, to be able to brainwash people, to be able to stand up in a podium. And he looked nervous, if you ask me. Like, I've watched that video so many times. He did look nervous. But to be able to get on a podium and read something that allegedly was written by someone else, right? Jill Daniels, they say. That's what, it's running through the grapevines. Jill Daniels wrote his speech, detailed names. But did you notice that Brian Higgins' name was not included on that speech? As much as there's a lot of people that have been involved in all of this and following the Karen Reed and the Boston police officer John O'Keefe's murder from day one, there's also a lot of people that are new at it. There's also a lot of people that did not follow it from the beginning, and they're just getting involved, or they're just hearing about it and trying to figure out what happened. A lot of new people. And you wonder, have they gone back? Have they, do they know the relationships behind these people? It's just like the Murdaughs. These people have been living in that state, and they've owned half of the city, if you ask me. For years and years and years, their legacy has been unquestionable. They have been prosecutors. They have been involved in lawyering and finances, and made an imprint on that state. And then look where they are because of somebody's wrongdoings or greed or addiction to drugs or whatever it was. We have how does that happen? How do you go from that to where he's at? From what his grandfather did, his great-grandfather did, his father did, to this. How do you go there? How do you jump? If it's not a generational thing, if it's not because at some point, as kids are being born and raised in different generations, something is lost. So what is it that is lost? Is it the values? You would think it isn't, because they get transferred, right? Your great-grandparent passed it to your granddad passed it to your dad passes it to you. That's how it works. So what is it that is lost? How do we go? It's just, oh, good. I hope you have a good day, sweetheart. Hope you have a good day. I'm working too. I'm trying to put all this other stuff together. There's a lot going on, especially with the Celebrite portion of it. This AI thing, just jumping subjects real quick. People are not happy. People are not happy. Thank you. They're not happy about where this digital forensic situation is going. You know, it's just opening the doors to manipulation. It's opening the doors to subjectivity. It's opening the doors to being able to shift and shape information depending on what's convenient. Unless the raw data, it's all AI is nuts. Now, I can tell you it is a time saver. Like I use it to write. I discover a few platforms that help me, like I can talk to it. And one more than others are better for me because, the only thing I have to go back and fix is maybe punctuation or the accents if I'm writing in a different language, or, the spellings or things like that. But it's a time saver because I can say, okay, so these are my thoughts, and I can read from my journals. I can read from anything that I may have written before, like, 40, 30 days, a year from now. Anything that I may have written on my journal, I can go back and read into it, and it just writes it down for me. So it makes it easier. The only thing that I have to do is copy paste and make it into a post on X. So for my particular situation, still with the damn cast, it's easier. But when you're using it to deceive, like the other day, I think, when was it? I think it was, it could have been Friday. I heard Higgins. All of a sudden I'm listening to YouTube, and I just put it on and put my earpods on, and I just go run and do stuff and leave the phone or leave the iPad or leave the computer anywhere. And I hear Higgins saying, yeah, Brian and I staged everything. And I'm going, what? So I'm running from where I was, and I'm running towards the device that I was using. And it was a video, an AI video, that he was sort of like mating to make believe that Brian Higgins was saying that him and Brian staged everything, and they put the Ford Edge by the flagpole, and it was all done by AI. And I'm going, you know what? I thought it was like breaking news or something. So I ran. Oh my God, silly me. Yeah. So it was our friend, Loopy. But, go figure. I should know by now. Okay, I'm checking 3 different channels and they're all still muted. This was supposed to start at 10. There is a New Jersey hearing too that I don't want to miss it, because that guy has something to do with the disappearing of a woman that is still missing in South Carolina. And he's appearing in a courtroom in New Jersey. And I don't want to miss it. But yeah, they haven't started yet. As I'm here staring at the same screen you guys are staring, I'm checking other channels, local channels, Law and Crime and Court TV, and they're all still muted. So let me see this one. Let's see if, okay, so we can watch this one. Let's see what people have to say while we're at it, because we don't have anything else to do. So we are supposed to have a heat wave this week leading to the 4th. Don't know where she's at. Cupcake 414. We used to go down Central Park Beach in the summer. Water was 55 even when... Okay, they're talking between themselves. They're not talking. Rick Shaw killed Murdaugh's wife and son. Rick what? Who's Rick? Rick Shaw. Who's Rick Shaw? Or Shaw? Chow. Jesus Christ, calling and makes Instagram look honest. Jesus. I guess those people are from here. Huh. Well, that's interesting. Let's see who Rick Shaw is. Let's see. Um, 61-year-old former convenience store owner in Columbia, South Carolina, who was recently acquitted of murder in a highly publicized trial. Which trial? On June 1st, 2026, Richland County found Shao not guilty in the 2023 shooting death of Cyrus Carmack Belton, a 4-year-old black teenager. Who the heck? Okay, so what's the relationship? What's the relationship with Murdaugh? Tell me. What? The courtroom is full of people. Mm, had I known, I would have gone. 4 hours, but it's a nice trip. So let's go back to this and see. So the relationship with no personal relationship. Um, there's no relationship, it looks like. So why would she say that? Let's go back to this one. I have no idea who the judge is. You're kidding. So it says that the Circuit Court Judge, Deborah R. McCaslin, is presiding this. I'm not sure yet whether it's true or not, but it says that there's a twist here because she is a former law school classmate of Alex Murdaugh. She attended the University of South Carolina School of Law and graduated in 1993, 1 year ahead of Alex. Well, that would be interesting. Can you believe it? Deborah R. McCaslin. Yeah. Clifton B. Newman was the judge in the past, and he since then he retired. There was a lot of personal stuff that were going on for Judge Newman during this trial, and nobody ever knew. But let's see. Oh, they're pointing at the camera. They're pointing at the camera. Yes, the camera's right there. Mm-hmm. Here we go. It's her.
Please be seated.
Oh,
I see we have a full house. Good morning. For those of you who've never been to
Let's go to this one.
All right, we're here for a status conference.
Indictment number 2022 GS 15-00592 through 595.
Thank you. All right, Mr. Waters, how are you?
Morning, Your Honor. Good to see you.
Good to see you. Now, let me ask you, I know some of your counsel at the table, but I don't know all of them. Can you please just let me know who the state's team is?
So I have David Fernandez, Assistant Deputy Attorney General David Fernandez. He's my number 2 in the state grand jury section. I have my boss, Mr. Don Zelenka.
I know.
We have John Metters as well.
I know Mr. Matters.
And then, you may see at various times, we have Assistant Attorney General Walt Whitmire, Senior Assistant Deputy Attorney General Melody Brown.
Right, welcome. Let me, Mr. Harpooling, can you tell me, I think I know just about everybody at your table, maybe not everybody, but can you introduce the defense?
Please report, Your Honor. This is Jim Griffin.
Mr. Griffin?
Bill Barber.
Mr. Barber, good to have you. Okay. All right. I've made some notes on a status conference, and I'll let y'all talk in just a little bit. But I want to go over what I want to go over. Because I want to make sure that all the discovery in this case is complete. And I made some notes, and let me tell y'all, I don't know anything about the first trial, so when you tell me something, please be complete when you tell me, because don't assume that I know, because I don't. I want to know about phone records. Do we have all the phone records, and are they complete? Text messages, cell phone extractions, and if there's any supplemental extractions, video recordings, whether there's ballistic firearms, are we complete in that? Fingerprints, toxicology. I think there was a blood splatter expert last time. I just want to know where we are with these discovery items. I'll let the state address that, please.
Yes, ma'am, Your Honor. So we have provided, and obviously provided well in advance of the first trial, a very extensive discovery. I'm not aware of anything in the items that you mentioned that have not been provided to the defense. And if anything, the defense has more than the state does, because a very heavy privilege review was done, for example, on Murdaugh's phone, and formerly named an attorney, and that sort of thing. So it's my understanding, complete extractions were provided to them, whereas the prosecution team, the investigative team, only received the privilege review cell phone extraction as it relates to this phone and that sort of thing. As always, we are constantly auditing and looking at everything, but I'm not aware of any discovery from the very extensive productions that were made, not only from just the murder investigations, but also from the very extensive state security investigations as well. So we have provided those, and obviously, I'm not aware of anything in the categories that you mentioned that have not been provided to you.
And not anything that needs to be reanalyzed or anything that the court would be waiting on?
At this time, no. Now, as you're aware, and we, of course, sent our responses to everyone last night to the defense motions that were filed late last week. Came in the office Sunday to write those. One of those is their request for independent testing on DNA. So we put it on motion, and I actually got an email from Mr. Griffin this morning that if they want to have their defense expert reach out to SLED as to specifically what capabilities they think they have and what they're proposed to do, happy to facilitate those conversations and discuss those with the defense, and then with your honor if necessary. Right now, that's kind of where we stand on that. And of course, any other issues that arise along those lines, we're very reasonable and we're perfectly willing to discuss those with the defense. And if there's something that we can't agree on, obviously we'll raise this.
Okay. All right, Mr. Harpootlian or Mr. Griffin?
I want to address everything but the DNA issue.
Right, I'll talk about the DNA later.
So we don't know what we don't know. And I'll give you an example. Let me hand this up to Your Honor and hand copies to. Your Honor, this is a transcript of an interview done with a guy named Chapman and another officer who were folks that arrived on the scene to begin with, processed the scene, and were very involved in forensics of processing the scene. And if you go to page 6, Chapman, who's in charge of the scene, says this. This is a television interview on March 13th, 10 days after the verdict in this case. He says, in response to the question, I believe he had some help in the aftermath. Or Rutland, yes, Captain Chapman. You know, the disposal of weapons, the moving around a vehicle. We heard so much about Sweat and AG's office, they don't have anything. It's all circumstantial. So I pose this question to you. It was a clean crime scene, stage crime scene, clean crime scene. Would you expect to find more evidence or less? And that's what's kind of hard to get people to understand is we didn't find a lot. But why we didn't find a lot? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is not what Chapman testified to. And if Chapman has evidence, there were other people at the scene, that he had assistance under their theory, or there were other people there. We need to have that furnished to us. And we have other witnesses that testified at trial are saying something totally different, indicating there's evidence to believe that somebody else was at the scene, or there were other people at the scene. I mean, this guy's the chief guy in charge of the scene, along with Rutland, who processed it that night. We need, and we're in the process of doing this to determine that they did other statements or the reports. So we don't know what we don't know. We don't know what we don't have. We need some period of time to try to process that. And Your Honor, I say this, and no emphasis on trying to, we're not alleging that the state has hidden anything from us. We do know there were people that came to see us that said they had important information. We have no ability to investigate anything. We don't have subpoenas. We don't have grand jury. We don't have search warrants. And 2 or 3 of those people we sent to SLED. Did they follow up? One had extraordinary evidence about a tie-in between Paul's murder and the murder of a young man named Stephen Smith. But we had no, I can't compel anybody to come anywhere. We sent that to SLED. Did they investigate it? Have they investigated? And I must tell you, there are a lot of pieces of information out there that, and maybe they just stopped once they got the conviction, didn't do anything else, that it's inconsistent with our desire to get a conviction, have the conviction held. So they didn't follow it up. Maybe it does need to be followed up. But we're going to have to go back and look at all of that. We're going to have to determine whether or not additional material developed since the trial. And of course, all of us were shocked by the court's conduct in the trial. I know we were, I know the state was. But it's hard for us to go back and look at, and we haven't done a thorough check of it, all the testimony and read it all, not in the sense of an appeal, which we've done, but in the sense of, I mean, in criminal cases, we don't have depositions. We don't have them here. We have a transcript of but not every, I'm sure they're going to get rid of some of these witnesses who are horrible the first time around and get additional witnesses. But most of the witnesses, we have their transcript, their deposition. We need to go back and read all of that, and we need to get a sense of how you cross, like you would in a civil case. So I can't say that we've got it all. I can't say that we don't have it all. Again, I don't know what I don't know, but I think we will be very diligent. And one of the other things we talked about is Murdaugh's access to that information in a way that makes it convenient for him and doesn't inconvenience anybody else. We'll talk about that. That's another motion. We'll talk about that.
I'll get to your motions in just a little bit. What I really want to know is about phone records, text messages, cell phones, video recordings, toxicology, fingerprints. You have all that discovery.
We're not sure, but we need to review it as if we were getting ready and brand new. I can't. Just because we looked at it 5 years ago, 4 years ago, doesn't mean we know we have it. We'll be diligent in doing that, but certainly I would think it'll take us some period of time to review that.
Yeah.
Right. One of the points reminding me, we did not have OnStar data on Mr. Murdaugh's vehicle until halfway through the trial. That is not the Attorney General's fault. That is GMC's fault for not furnishing it. We had to do that on the run. We want to go back and analyze that, have an expert analyze that even more. I do on the other side, the Attorney General got it at the same time we got it. No inference, anything improperly.
Okay.
So that's part of what we need to do. We need to hire additional experts based on some of the views we now have on some of the witnesses, both the state and the defense have. And they need to examine those reports to determine whether we have it. So it's going to take a little bit of time, Judge. I can't tell you today we have everything because we don't know.
Okay. Let me ask you, Mr. Waters, what about the OnStar data? Do you have all of that?
Yes, ma'am. So, Your Honor, we actually SLED and sent 2 search warrants to GM well in advance of the trial, and we're told we ain't got it. And I think what happened was during the course of the trial, we actually had the FBI buy a Suburban and essentially reverse engineer the black box in the Suburban in order to provide us telemetry package. Of course, it's all provided to the defense. I think when that testimony came out during trial, somebody at GM was watching and they were like, uh-oh. And so in the middle of the trial, I get a phone call saying, you know, about all that OnStar data, actually, yeah, we got a bunch of it. We immediately advised the judge, advised the defense, provided that to a usual form. They assisted and agreed to go forward because each hour of theories about what had that next. So that was nothing with the fault of the state, and we immediately engaged in what we needed to do to ensure the defense had access to all that information. After him saying, we don't know what we don't know, well, I know my obligations are, and if I have knowledge of something that's disclosable, then it's been disclosed. And so to imply that there's something out there, I mean, we're always constantly auditing that and doing our obligations, but I take discovery obligations very, very seriously. And our group knows that. As far as these musings, I haven't watched this TV interview. The musings of some captain about, you know, whether the scene was clean. Well, there was evidence presented at trial that there was standing water on the concrete pad of the kennels, that the hose was not put back the way that it normally was coiled by the person who was in charge of taking care of the kennels. So he may have been talking about that, but ultimately, while Colleton responded initially, the scene actually was in charge of the process by SLED, and they had access to all that information. So to sit here and imply, you know, we don't know what we don't know, well, I'll recognize that, but I know that my obligation is to provide that information to the defense, and if I'm aware of it, then it's been provided. And we have done that. They've had it well before the original trial, and we will continue to do that. And as he freely recognizes, the OnStar data came in late despite our best efforts and was immediately disclosed to them. They had every opportunity to process that information, and then they agreed, you know what, let's continue on. So that's not anything, any sort of indication of a bad process or practice.
So the bottom line is they have everything that you have.
my knowledge, yes, ma'am, and we were very careful about going through all that discovery.
And you don't know of anything else that needs to be analyzed at this time?
Well, again, we have that DNA.
The DNA, and I'm going to get to DNA in just a moment.
Of course, it was analyzed ahead of time. Now, what they're
Right.
talking about is some additional capability, as I expressed in our motion, and Mr. Griffin has responded. I'm happy to facilitate discussions, and if there's some capability out there that's beyond the capability of SLED, and it has a reasonable chance of providing some sort of analysis, then we're happy to do that. Now, of course, as we put in our motion, ultimately, there's absolutely no evidence that Maggie Murdaugh was in a struggle with anyone, that she had any sort of defensive wounds, that she was scratched any sort of attacker. And we also know that it's very common with how sensitive touch DNA is. We're constantly shedding DNA and picking up DNA from others by shaking hands and doorknobs and all the rest of it. So, this is a bit of a red herring, but that doesn't mean that we are not willing to discuss with the defense anything that they want to do, and if reasonable, we'll be the first to do that. And if there's any needs to come back to this court, we'll do that as well.
Okay, thank you. Sure.
We know from testimony in the first round that the chief SLED officer involved admitted he misrepresented things to the grand jury. Since the trial, the case was dismissed, in which he testified because the judge found he was hiding evidence and misrepresenting that. That's the chief officer. No other SLED, but it raises questions with us, not whether it's been withheld by the state, by the prosecution, but did he give them everything he had? Did he do what he did in the subsequent case after the trial where he had evidence? And I think we've got to go through it and look and say, are there gaps here? Are we missing something? And for us, and look, we want to try this case as quickly as possible. But what we don't want to do is not be prepared based on what we now know happened at the first trial. And we'll have a motion probably next week that will expand on that a little bit. We didn't feel that we wanted such a motion.
Well, and I don't. I really wanted to go over and see where we were with discovery. I want to set a timeline. I want to set out some pretrial conferences, and I want to set a trial date. That's why we're here today. And I want to go over some of these motions. I think some of them are not substantive, that I could go ahead and rule on those today and be done. And I will set up a pretrial. I'll give y'all some dates and hope you brought your calendars. And we'll set a pretrial. I don't know that one pretrial is going to do it for this case. We'll probably have several. And that's fine. The court's amenable to anything that y'all need. And happy to hear what you have. If you find something, Mr. Harpootlian, that you need to bring to the court's attention and you want to file a motion, I am more than happy to hear it. Okay? All right, so let me move on to my next notes. And we've kind of touched on it a little bit. Experts. Do you know how long? And the reason I'm just asking is because I do want to set a trial date. Believe it or not, overnight when I was assigned this case became the oldest case on my docket. And anybody who knows me knows that I will move an old case. And I intend to do that with this one. So I'm asking Mr. Waters, expert witnesses, do you know how long you need to get expert witnesses and talk to people and get everything that you need for the prosecution of this case?
Yes, ma'am. So the vast majority of our experts will be SLED. So I think that we are ready within reason, of course, to move this as expeditiously as possible. We do have another expert that testified from the FBI and things like that, but much of that is the same. And so as far as the state's position as to scheduling, and I know we've already sort of stated this publicly, that we were trying to do this before the end of the year, right before the end of the year, we're ready to go. So I'm not aware on the state side of any expert issues that provide for additional delay.
All right, Mr. Harpootlian, how about for the defense?
John, we have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need. The DNA, when we are told, may take up to 6 months. It is, unlike what's been represented by the state, critical. And Mr. Griffin will address the specifics of that in just a moment. But to try this case this year, these guys are talking about going to the death penalty 4 months ago or 3 months ago. To try it before the end of the year cannot be done for us to be adequately prepared. And we talked about the laptop. Without the laptop, we can't try it next year. If we have to go down there and take in the banking box at a time for new documents, almost 20,000 pages of documents. So we came up with a way to expedite.
Well, surely, Mr. Harpootlian, he reviewed those before his first trial, did he not?
5 years ago. I mean, it's just a judge. I can't remember a case I tried 3 months ago when the material was on that. I mean, it's ridiculous to require him, not with all due respect, to require him to have a memory of each document that he looked at almost 5 years ago. And by the way, our solution to that, contrary to Mr. Waters' motion, is ironclad, no chance of it being distributed. We'll give them a laptop that's encrypted, that since there's no attorney-client on it, corrections can look at it, SLED can look at it, anybody can look at it, and let him look at that without us having to take hard copies of stuff down there and review it with him. Can't leave it with him under the court order. In other words, you just can't take him to discovery and leave it with the court order prohibiting that. And I'm sure the warden does not want boxes and boxes of stuff sitting in his. But if we have that, and he could be reviewing these documents and experts as we're reviewing them. I mean, let's not forget, he's a lawyer. Now, he's a disbarred lawyer, but he has probably more trial experience than many of the folks on either side of this court. So he understands what he's looking at much better than any client I've ever had. So I think it's important, if you're going to try to expedite this, for him to have, and we can talk about the laptop separately, but that's going to be a condition. It's going to take us at least 6 months to get these folks retained, have them look at the adequate material, look at the state's testimony the first time around. And of course, if they have a change in who they're using or taking a different approach, we need to know that as soon as possible. I would point out that they were giving us discovery in the last case after the first week of trial, in the second week of trial. So we can't have that happen again. They say they've got it all. We're going to assume we have it all unless they want to supplement it. They supplement it sooner rather than later. That allows us to try. I mean, I think what we probably ought to try to do is figure out a trial date and then back up from that. And what we're comfortable with is late spring, early summer next year.
Okay.
We can live with that. Given, I mean, if we have to go down there, one of us has to go down there 5 days a week, and we may be incarcerated on an house, so it's 2.5 hours from here. It's a half an hour to get in. So before they ever even see it, it's 3 hours. And then you only have 3 hours with them, and then it's a 3-hour trip back. That's why the laptop is so important.
Okay. Mr. Griffin, anything you'd like to add as to experts?
I have been in contact with the DNA lab in Houston. I can talk more about that. But when I mentioned that, they were asked, how soon do you need it? And I said, well, hopefully we're looking at a spring, early summer trial date. And the answer was, well, we need to put a rush on it. And I can talk more about the lab if Your Honor wants to hear it. I mean, they are the.
I'll get to the DNA in just a minute. And then we'll go forward on that. All right, let me talk about this computer at the Department of Corrections. I did receive your response, Mr. Waters, yesterday at 5. Did you get the opportunity to look at that, Mr. Harpelian? I mean, basically, I just made myself some notes. You were concerned about the state grand jury material and talked about a protective order and some other issues. I agree about there are some sensitive issues. The state grand jury material is protected and should be protected. And then you mentioned an order that Judge Newman had. I kind of think, Mr. Waters, that when this case was reversed, that order goes out the window and we might need a new order for this case. It's my understanding that the order stated that the grand jury material is secret. And I mean, that's pretty straightforward. And I know that you would like to prohibit the digital dissemination of the state grand jury material, that there's no photocopying, scanning. I breezed through this. You don't want any digital copies. And all of this, while it doesn't prohibit the defendant from reviewing the case materials, you want the attorneys to make sure that they keep in their possession the state grand jury material. Is there any objection to that, Mr. Harpelian?
Your Honor, the issue of that is what is the state grand jury material? I think, you know, we can designate what that is. It's beyond grand jury testimony, which is, there's very little of that in the discovery. I think they've gotten things through grand jury subpoenas that have been produced, you know, underlying records and whatnot. And so, you know, is that really sensitive grand jury material? And some of us introducing the evidence at the trial, I'm sure of that. But so no question about grand jury testimony. We have no issues with that. But it's just hard to say what exactly are grand jury materials when a lot of subpoenaed documents and information have been produced.
And Your Honor, the issue is dissemination. I mean, he has a right to read.
Oh, absolutely. I said that. It does not prohibit him from reading it.
Dissemination. I mean, this we're just basically talking about a big Kindle. You can read on it. You can't send emails. It's not connected digitally or cell or Wi-Fi to anybody. It can be kept. Let me say this: the Department of Corrections has been extraordinarily professional in dealing with us, giving us access to them. But no complaints with them whatsoever. But what we like is we like that laptop with the warden and corrections have total access to it. It can be inspected by SLED to make sure that it can't transmit an image, a message, can't be used in any way. There is no Wi-Fi at this particular institution. So it has to be by self-service. And these are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's 1% of what we want them to look at. And we can certainly do that separately with hard copies. We'd be happy to get out there and do that.
Well, let me tell you. Well, Mr. Waters, let me hear from you first.
Yes, ma'am. So we really, as far as the protective order, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that. He's pled guilty to all those offenses. There's nothing commercial about that. But necessarily, as that state grand jury investigation was going, things came up that were ultimately relevant to the murder. So it's much bigger than they say. You know, I don't have the number in front of me, Your Honor, but it was at least 20 witnesses, multiple subpoenas. And so all of this has been dynamic. And as well as Judge Newman issued a second, to my recollection, protective order as related to just sort of the murder evidence as well. So they're two separate things, but they all blend together. So all of this evidence is sensitive. On top of that, the murder evidence is in fact very, very sensitive. And frankly, we've been trying our best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away for misuse of that. This is an individual who was caught receiving contraband that was passed from a family member who was kind of a guy. And so this is not a guy who is, and this is also a guy who's been convicted of over a decade of fraud. Now, they say that these things can be locked down. I understand the issues here well. The state grand jury made a choice to partner with us to fight the problem of fraud and corruption emanating from there, and it's done with the use of devices. This is a very severe security issue. No matter what protections are put in place, there's always ways around this, and SCDC has experience with that. So the fact remains is he's an inmate, and SCDC is adamantly opposed to there being some laptop that he has access to. And for this idea that SLED is going to be able to review, attorney communications and work product on that, I don't understand how that's going to happen. Now, SCDC is happy to accommodate the defense and to any meetings they have, and no one says that the defense can't bring down digital evidence to review with them while it's under their supervision and then take it with them when they leave. That is absolutely the way it should be, that ultimately this information, whether state grand jury or not, is too sensitive to have an inmate, despite what protections are put in place, have a laptop, because frankly, the reality is inmates are constantly and successfully violating whatever protections are put in place. Despite everyone's best efforts, you're doing a great job. It's just a mental.
Okay, sure.
I had a series of emails, and I don't see the Department of Corrections here today objecting. I had email chain with the ward at the particular institution, and he doesn't raise those objections. He just, and we bring another laptop with internet cellular or Wi-Fi capabilities. So. And that's what this says. So, and with all due respect to the Department of Corrections, if you don't get the ability, I mean, if Mr. Griffin and I, or Mr. Barlow, or Ms. Fox have to go down there, 3 hours down, sit with him for 3 hours, 3 hours back, we're talking about at least the end of next year, if not the beginning of the following year, to get this support. We can't be working on experts, and we can't be interviewing witnesses while we're tied to sitting there and babysitting him while he's reading a laptop that doesn't have any capability to communicate or talk. And we'll be happy to have SWED inspected. We'll be happy to have the Department of Corrections inspected. But, the idea, we bring laptops in. We were given, as you can see, permission to bring laptops in. Laptops are brought in all the time. The question is, can he keep, not he, but can the warden keep it, or some office at the institution keep it and give it to him when he needs it? And Your Honor, I gotta say, the idea of bringing him in here chained up, the idea of not letting him have access to a laptop, the idea of opposing everything we're trying to do to expedite this process. I understand it's Mr. Waters' job to legally prejudice the defendant, but this is beyond the pale. This is beyond the pale. I'd ask you to remind Mr. Waters that he has an ethical duty to see that justice is done, not to get a conviction. Thank you. I don't.
And that is,
Okay, we're not going to go there, but you.
and I have no intent.
Uh-oh.
Prejudice suggests a decision on the improper basis.
And the court doesn't take it that way, Mr. Waters. All right, let me tell both of you. I took the liberty of calling the warden and talking to him about the laptop situation. And because I too used to practice law, I remember terabytes of discovery that I had to carry to my clients to go see. and I know that it can be cumbersome, and I would imagine the discovery in this case is a lot. How many pages do we have, Mr. Waters?
It's very simple. It's
Half of a terabyte. Okay. I talked to the warden. He will not allow a laptop. And for safety reasons, he said he would, quote, make available a conference room. Council may bring their computer. They could have a law clerk come, or the attorneys could come themselves. They could look at it. He could review his discovery. They could bring their own laptop. However, somebody must be with him. His concern was having a laptop in his cell. No other inmate has a laptop in their cell. They do have access to an iPad that has Westlaw on it. Now, I just have to be honest with you. I didn't even think about asking him if you could download any discovery on that iPad. I don't know if that's available, but I certainly will call and check and see if that's acceptable to him. If that's the case, I'm going to have Mr. Waters draw me up a proposed order on the state grand jury material. I haven't looked at Judge Newman's yet, but I will. Please run that proposed order by Mr. Harpootlian and Mr. Griffin. I will check on the downloading on an iPad, but I'm not going to allow him to have a laptop computer in his cell. It's for safety reasons. That's out of my control. I think it's not only for the safety of the others at the institution, but probably, Mr. Murdaugh, for your own safety.
That's fair. That's fair.
We're not proposing he have it in his cell. We're proposing that the warden have it and give it to him to go to a conference room.
I can't hear.
Look at it there. Does that make a difference?
Well, I'll ask
Talk
you.
to the microphone, Harpootlian.
When I read your email here, this seems like he could go to his cell. He could keep it in his cell. I know good and well that the warden is not going to allow that. I talked to him personally.
We all know it.
Okay. To follow up on that and on next pretrial, or if I can, I'll probably let you know before pretrial. But if he says no and it's for security reasons, then the answer is no. I'm not going to allow it. Do you understand, Mr. Harpootlian? Mr. Waters?
Law clerk or other person, paralegal?
He'd let a paralegal go. All he wants is the name of the person, and you're more than happy. And he said he's not going to limit you to 3 hours. They can stay 8 hours if they want. He will make a conference room available so he could see the material. It does not have to be a lawyer. Okay, that.
Your Honor, I spoke with the director at General Counsel this morning, and they expressed the same thing. We're here to facilitate the defense doing that.
Right. You know, I want him to have all his discovery. He's entitled to all of it.
Yeah.
You know, it's safety concerns. It's if you can have a law clerk or a paralegal go down, then you're satisfied, Mr. Harpootlian. That'll help you out.
Automatically, we're not limited to 3 hours. It makes that 2.5 hour trip down and 2.5 hours back worthwhile.
Okay. Well, then I will verify that and send y'all an email tomorrow on that. That's okay. All right, perfect.
Thank you, Your Honor.
All right. Now,
All right.
let me go through.
All right.
I had a motion filed for the defense, and I just want to put this on the record. The defense wanted the defendant to be unshackled in the courtroom. I received a response from the state. They objected. Then I had a response from Mr. Harpootlian where he withdrew that motion. That still stands, Mr. Harpilian?
Yes, Your Honor, although we may renew the motion, the reason for this is potential jurors are watching this right now. It's going to be, wherever this goes, it's going to be difficult to get a jury. And
Pick
the
your
extent of
battles.
just parading him around in a jumpsuit shackled like an animal impacts their view. It's going to make it more difficult for us to get a jury. Now, again, Mr. Waters' argument is specious. He's not dangerous. The only thing he can convict of is stealing money. Now, Judge Newman let him come to the courtroom in street clothes and unshackled. I know Mr. Waters feels compelled to get every advantage he can, but this is one that I think this is our ability to get a jury. So I would ask that he be allowed to come in the courtroom unshackled in, I would call them street clothes. Now,
So are you renewing your motion now?
Yeah, because you
Wanna make
just,
sure.
what I wanted you to see today. Chains around the waist, chains on the hands, chains on the feet.
speak to the microphone.
Ted Bundy.
You can sit down, Mr. Murdaugh.
Always convicted. He was accused of killing his wife and son. But he was accused of killing his wife and son. And Judge Newman allowed him to come unshackled in his street clothes.
You already said that.
All right, Mr. Waters, I did read your response, but I'll be happy to hear anything and I'll take it under advisement.
Well, again, they withdrawn the motion and now they.
Now they,
This goes back to, it's not the state's fault. He's an inmate serving a 27-year sentence.
True.
Okay? This is again, SCDC's policy for non-jury court to be dressed out in their restraints. He's not only facing 27 years, but an additional 40 years in federal court, and he's also indicted for a double murder. So this is a basic security consideration. Again, the intent is not to prejudice anyone. The intent is the security of every time someone is transported out of court. It is a security risk. And the first two goals of any escape attempt is to become unrestrained and in civilian clothes. So I'm here to represent what is basic policy and procedure for inmates serving long felonious sentences with SCDC. I completely understand that we have a jury, the calculations are different, and that is going to be a different thing to do. The remedy for all of that ultimately is with our process. It's going to be a jury selection, and it's going to be instruction from the court, which the jurors are going to follow, and which I know our citizens can.
okay, thank you. All right, I'll take it under advisement and I'll issue an order on that. Let me move on to the DNA. Again, I just received the state's response yesterday at 5 p.m.
Jeez.
I read it, and I'm going to save it for the next pre-trial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
Okay.
So
And
that was conveyed to them this morning. The CEO of Othram's name, email, and telephone number. They have received the VP of Law Enforcement Division at Othram, his cell phone number, and the client intake person that we use now, that I've been interfacing with, and they will be better able to answer specifically how long it will take. We've agreed to pay for it, and just background information.
I'm going to let you pay for it.
Yeah.
Oh my.
These murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genetic genealogy was just on the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Othram is the leading lab that performs this analysis. They did last year on 2024. The statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high-profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho. They had a DNA sample they ran through CODIS. Came up nothing. There was nothing. The state of Idaho Police Department, like SLED, had a contract with Othram. They sent the test Othram. Othram does this genetic genealogy DNA analysis, and it comes back to a family member who'd done a DNA test, ancestry test, of the person who committed these murders, Brian Koberg. That's how they solved the Moscow murder cases, was through Othram Lab. The difference between, and they say they don't have enough samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses analysis called STR.
Mm-hmm.
This analysis is SNP, and they call it SNPs. CODIS has 20 data points. SNPs has 500,000 data points that they analyze. Now, it takes a while to do that. And so, we're going to have to see what the lab says. They've asked me to get information from SLED as to, they'd like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd ask Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. There are handfuls of labs around the country, and they are they're certified. They work with law enforcement. I don't know that they've worked specifically with SLED. They're familiar with SLED when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send.
Correct. And they can work with the extract that SLED used when they did their STR analysis. They can work with that out there. That they told me. But
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED.
No.
Talk to them about what they're supposed to take.
Here we go. Ping pong.
And any procedures, and then made privy
Can
to
you
that information. I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll go back to Your Honor. That's precisely what I put in my motion. Is let's talk to let the experts talk, so that my experts can hear what it is that they propose to do. I'm happy to research.
And I gave him 3 names and contact information this morning, and I've asked a name that I can send back to my folks. I do want to address this red herring argument.
Ping pong.
The DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alec Murdaugh's. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential, and that potential, the ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be, innocuous. We don't know, but it's worth looking into.
Okay, I haven't said no. This is what I do want you to do, though, Mr. Griffin. I want to know how long it's going to take to analyze what it is that you're asking for. And even if I expedite it, I'd like to know how long it's going to take. And I'd also like to know if there's even a viable sample that they can get. And we will discuss this at our next pretrial.
Wow.
Anything, Mr. Waters, you're going to give them the name of the person that SLED that he can get in contact with. Let's see if there's a viable sample.
And the lab has told me if there's not a viable sample, we'll tell you that. But
Right.
they work with a lot less than.
Okay. Well, let's start with that. Let's make sure we get a viable sample, and then we'll go forward. And we're going to go forward at the next pretrial. I promise you, the pretrial is not going to be that far away.
Oh.
All right.
All right.
Let me move on to the motion for change of venue. The defense filed a change of venue motion. The state has not had the opportunity to answer yet. So I'm going to give them time. In the meantime, before our next pretrial, if at all possible, if y'all agree on a change of venue, please give me some suggestions if y'all can agree on it. If you can't, make your own suggestions, and then I will decide for you if we go that route.
Even in spite of the acrimony here today, the lawyers and they able to talk to each other, and we have already talked about this. I think we'll have continuing discussions. Depending on what you say or that
An answer for me?
I don't have to drive you down.
Yes, Your Honor. Of course, without taking a specific position right now, I
Right.
start feeling this morning that we can kick some things around, and like you just said, if we agree, great. If we don't, so.
That's right. Don't have a problem with that. Okay, perfect. All right, now let me address. I see Mr. McCullough sitting out there, and then I also have another. They're both the same protective order, but they're wanting two different things.
Not the same as this.
That's right. They're two different things. Right. As far as, but I think before we go there, Mr. Harpootlian, I believe, Mr. Waters, am I correct in stating that you're working on a response to both of these? There might be some redactions that you wanted, and you're going to submit that to the court? Okay, and I'll be able to address that at the next pretrial conference.
Again, we are generally in favor of those being unsealed, but they will have to be done judiciously and with appropriate redactions to preserve their identities.
Right, because I did, yeah, and I did receive something from SLED, an email from SLED. Where is he? Okay, I did receive your email, and just get me an answer on that, and we'll decide at the next pretrial then. Okay, those were all my bullet points. So let me ask the lawyers, did I miss something? Is there something you would like to add?
One thing Your Honor had mentioned is the location of pretrial hearings. From the state's perspective, we're happy to come wherever Your Honor happens to be.
Okay.
And we're more than happy to come wherever you are, although this production of these hearings might not dictate, but certainly suggest we come to a venue like Washington County, where there's plenty of room and get an extraordinary accommodation.
I think they've done a really good job with security and with the press and being organized. And this is my home county. Let me just ask and throw this out there. Mr. Waters, is there any objection if we hold pretrial here? The reason being, we have a big courtroom. I already have security set in place. I think the clerks and both clerks and security have done a really good job. This is not the only courtroom in this courthouse, so I won't disrupt holding court in Lexington, which I would not want to do to any county. Sometimes I go to really small counties, and I don't think it would be good to hold a pretrial there. Does it suit?
I mean, from the state's perspective, and again, being a longtime AG, I've been in pretty much all of them. And as an AG, Lexington is like a second home, obviously.
Convenient.
Solicitors, obviously, law enforcement, the court, of course, is very accommodating here. So this is certainly, I think, would be of most convenience for parties as we get ready for
Okay, it's not far for anybody to travel, Mr. Harpelian? Okay, and I will try to make sure that when we arrange these pretrials that we will try to be here in Lexington. Anything else, Mr. Waters? Defense?
That's all we have, but if we could talk about that schedule for the next pretrial.
Oh, I'm getting ready for it right now. Let me tell you what I have.
Wow.
I've gone through my calendar.
Jeez.
And so it's hard to get lawyers together, especially when I have this many lawyers. So let me throw some dates out to you. August the 13th and the 14th. July 29th, the 30th, or the 31st.
Right, so chronological order, the first would be
July 29th.
I'm scheduled to be out of state from the 29th to the 31st.
Well,
okay, then let me move on to August 13th and 14th.
Your Honor, we have a mediation on the 13th.
Ah, bueno. Here we go.
August the 14th it is. That will be our next pretrial. Now, with that said, I'd like to have all motions by August the 7th, if I could. I like to read my motions. I like to be prepared. So if I could have your motions, I understand that some of them are late. You might think of something at the last minute, that's fine, but please don't file something at 10 o'clock at night and expect me to rule on it in the morning.
Wow. Expectations are set.
No, you're fine.
Just to make sure we had something else.
Mr. Waters, you're fine.
Mr. Waters.
I was not planning on ruling on those motions.
Waters, you're fine.
Had I been, I might say something different. But please don't do that to me, okay?
Oh.
Now, let's talk about a trial date. The only other information I would like to know is how long this DNA is going to take. I would like to know that, but I'm going to tell y'all, I'm thinking April the 5th. And this being, I'm trying to get through Easter, and I know how hard it is to pick a jury when you've got spring break. That's usually right before Easter. It is the March. Is it the 28th? I think it's just a week. It's March 28th. So I'm thinking April 5th. I know that we'll have a new attorney general coming in. Mr. Harpelian has already told me it's going to take 6 months to get experts prepared and ready to go. That would give the new attorney general time to look at his case in case He's going to be here and join us. And let me tell you this, tell both of y'all, I think y'all know me pretty well. When I set a trial date, I don't do continuances.
Oh,
I don't do it. It better be a really good reason. So, how does April the 5th sound, Mr. Waters?
We'll be ready.
Mr. Harpootlian?
We'll be ready with some contingencies if the DNA takes longer, for instance, or
I will have that information by next pretrial. If I need to extend it out a couple of weeks, I will, if that's the case. Please do not think that this case is going to be tried a year later, because it's not.
oh,
We're going forward.
more than happy with that. Mr. Murdaugh is more than happy with that. I just, again, everything.
Oh my God.
Like, because the science in all these areas is much better than it was 5 years ago.
I understand technology changes overnight. Overnight, I understand. Mr. Griffin, anything you'd like to add?
Yes, Your Honor. The Supreme Court reversed this case on misconduct by clerk of court, but the Supreme Court also addressed financial crimes evidence, and depending on how much of that or any of that comes in, will determine the length of the trial in many respects. Judge Newman last time would not rule pretrial on that issue, and it is going to be an issue that we're going to have to brief and argue with Your Honor as to, we don't think any of the financial crime evidence should come in at trial. And so I'm just flagging that it would be helpful to us, I believe, and to know if we're going to have to defend against that during the trial, or are they going to be able to put it up? And so I'm just asking maybe some earlier date where we can have, Your Honor, address those issues.
We will. I'm just going to tell you, I like to address all pretrial matters beforehand.
This judge.
Because when I say April the 5th, we're picking a jury and going forward. All those issues should be decided by then.
Well, we filed extensive pretrial motions prior to the prior trial. Laying all our cards on the table is exactly why we felt that was admissible.
Thank you. I appreciate it. Anything further before we adjourn, Mr. Waters? And Mr. Harpootlian?
Nothing with it.
All right, perfect. Have a good evening.
And she's done. Well, that was a wrap up. This judge is no joke whatsoever. So for those of you who missed it, this was a straightforward, to the point. Well, he's saying thank you. I guess he's happy with the outcome. They are trying to here, I took some notes. Let me see. I'm gonna wait. I want to watch everybody walking out. And yeah, so this is not gonna be delayed. My impressions is that the judge is going to be a pretty straightforward, no BS judge. I don't know if you guys saw my post, but she knows Murdaugh. They went to law school together, and that is a major twist here. They both attended USC Law, and they were classmates. She graduated a year ahead of him, and it's amazing. Her name is Deborah R. McCaslin, just like that. MC and then capital CASLIN. This was like bam, bam, bam in no time. So pretty much the pretrial date is set for August 14th of this year, and that's on the docket. Like, it's not officially on the docket, but that's what they just agreed to. It looks like it's going to be a fast track timeline, because setting August for the pretrial means that she wants the trial to be on or about April 5th. That's when she wants the trial to start. So what she did stress was that she wants the DNA testing done, right? Like she wants it out of the way, like get together. And then they started playing ping pong, starting with what's his name? I forget his name, the one with the glasses, the prosecutor. Saying, well, but we sent him this and we sent him that. She asked a straight question and he started like sort of like dodging it. But what she wanted to know was what the defense lawyer Griffin said was that he had already sent contact information, email, numbers, and whatever, and they were waiting on the DA to say yay or nay, and then he started playing ping pong on that. But it looks like they're not going to allow him a laptop, right? Because he has been convicted. He's not going to have any special concessions inside the jail. And the shackles and chains, she took it over under advisement, so she's going to make a ruling on that. They argued and pleaded that even when Josh Newman was in charge of the prior case, he was allowed to come in civilian clothing and, not showing shackles on his ankles and all that. So I don't know how that's going to go. I have a feeling she's going to say yes, just judging by how, her demeanor and the fact that she's looking for efficiency, effectiveness, and it looks like fairness too. Despite of the fact that I know all of these people know each other, they all know each other. I mean, at one point or another, they know each other. But it looks like she's a no-joke judge. So we will see. She said she's going to remain strict on the datelines and that she wants all the pretrial motions filed by August 7th. Out of all of the notes that I took with my crippled hand, if I missed something, I'm still going to try to watch. If Melanie Little does this, I'm going to try to hear what she has to say because, I'm not a lawyer. I'm a Twitter lawyer. So, yeah, that was pretty cool. I told you guys that one of the things that I wanted to do was I'm trying to follow up on this case. And the case that is a New Jersey, and I think it was 9:30 today. So I may have missed it. Hold on. Let me see. His name is Bob McCaffrey, and he was supposed to appear court today. There's his missing wife is still, I don't know if you guys know about this, but here.
A New Jersey woman. McCaffrey also made headlines in 2012 after the disappearance of his wife, Marjorie Gale McCaffrey, whose remains have yet to be found. Our Cameron Lime spoke in an exclusive interview with one of Gale's sisters, who spoke about her experience with Robert McCaffrey and if this most recent development could help bring closure to her family. Cam?
We have no doubt that he killed her. Those are the words of Debbie Pearson, the older sister of Marjorie Gale McCaffrey. Pearson says she last saw her sister just 2 weeks before she vanished, leaving behind what investigators later believed was a farewell letter fabricated by Robert McCaffrey. She says her sister would have never walked away from her family, not with a stable job at the Citadel and as the primary breadwinner of the household. Pearson says Gale and Robert McCaffrey had 2 children during their marriage. After Gale disappeared, Pearson adopted both children and raised them as her own. On Friday, Robert McCaffrey was arrested in North Carolina for the 1990 murder of a New Jersey woman, Lisa Marie McBride.
So this is like so weird because I don't know if any of you know about this. So there's a 1990 case that he's tied to, but then he, I guess, moving around and whatever, he also married somebody in South Carolina. I don't know if you guys have heard of Citadel, which is, hold on. It's a military school. That's the same school where Nancy Mace graduated as the first woman who graduated as a cadet. It's pretty much like a military college, and it's very hard to get jobs within the Citadel. So the person that is still missing in South Carolina had a job at the Citadel, and that made it even worse because typically the people that work there have a very thorough background check, right, to be able to be employed at the Citadel. So you don't foresee anybody who is working at the Citadel with having like mental issues or suicidal problems or anything like that, and suddenly she's disappeared. So wait, where did it go? Where did it go? Hold on, here we go.
While that arrest doesn't bring closure for Pearson, she says it hopes it could bring her family one step closer to finding her sister's body.
We were shocked that he had killed somebody else, and now it makes me wonder if he's killed two, are there more out there?
Yep.
If nothing else, I hope it encourages the sheriff here to continue having her officers work on finding more evidence for Gail or pushing Bob somehow, that maybe he will give up information if he knows he's going to jail. I don't know what they can do.
ABC4 reached out to multiple agencies involved in the case today, asking whether this arrest could spark new leads or a renewed investigation into Gail's disappearance. So far, we have not heard back. We will continue to follow the developments on our website at abcnews4.com. And ahead tonight, how Pearson describes McCaffrey as a father and as a husband. Working for you, Cameron Limes, News 4.
So I've been looking to see if I can watch that hearing in New Jersey. I did find out that apparently somebody has been reporting on this for a long time. Like she's got all the tips, right? And I think somebody sent me her name. This interests me in so many levels because it's repetitive conduct. It shows that when you get away with somebody, with something, right? The first time, you're going to do it a second time. If you're not caught, you're going to do it a second time. So let me see if I can. Hold on. Let me see if I can find. I'm trying to get something. But hold on. Oh, please. Her name is, somebody send me her name. I'm looking for it. Delia Diambra. Apparently she's an independent investigative journalist. I don't know whether she's a real, somebody just sent me her name. She's got a Facebook page, Delia Diambra. I'm going to wait. And hold on. Let me see if I can. I think I found her. Hold on. And I'm going to start following her because she may not be on YouTube. Trying to see. No, she's just on, I guess she's just, doesn't she have a YouTube? She's got to have a YouTube. I'm looking. Here we go. Here we go. And home, subscribe, more, playlists. Let's see. Nope, that's not it. Come on, man. I'm getting there. It looks like she has abandoned YouTube. She only has 169 subscribers. That doesn't make any sense. And maybe that's that's one of her first YouTube channels.
Years, where do you find hope? How do you shut it off when you're really digging into a case and you're going, man, this is so brutal?
I remember pointing my camera and in the frame of my viewfinder, I just see this older guy come around the corner of the back of the building, and he's wearing latex gloves, and he is walking directly towards me, staring at me and the camera, and he just comes straight towards me and just jumps on me, just grabs me, threw me to the ground, like lumbers over.
Life is wild. Faith, marriage, parenting, work, all of it. 1 minute you're inspired, the next you're in chaos. That's why I started No Longer Nomads, the podcast that throws you into the deep end of real stories and authentic truth.
Cool.
We're talking ex-witches who found freedom, former Muslims who met Jesus.
But it's a little extreme too, so I'm not into the extremes. Too much to do. I don't have time. So wait. I need to find. Here we go. Finally.
We're on the record. This is State versus Robert McCaffrey Jr.
Wow.
There's no promise gavel assigned, but it's warrant complaint 2026-70, 1922. Another appearances.
Good morning, Your Honor. Assistant Sussex County Prosecutor Jerome Neidhart with State.
Good morning, Your Honor. Sean Russell, Officer of Public Defender for Mr. McCaffrey Jr., who is standing to my left.
All right, very good. Was Mr. McCaffrey provided with a copy of the complaint?
Yes, Your Honor. I provided him with a copy of the complaint and the PSA.
All right, very good. So, Mr. McCaffrey, you are charged as follows. On or about June 23rd of 1990 in Vernon Township, Sussex County, within the jurisdiction of this court, you purposely did cause the death of Lisa Marie McBride, or did purposely cause serious bodily injury to Lisa Marie McBride, resulting in her death. And that's a first-degree crime. You're also charged with committing burglary by entering a structure at a time not privileged to enter, with the purpose to commit an offense therein, specifically by entering 118 Glen Road, Highland Lakes, New Jersey, which was owned solely by Lisa Marie McBride, and purposely, knowingly, or recklessly inflicting bodily injury to the victim therein. You're also charged with committing the crime of kidnapping by unlawfully removing Lisa Marie McBride from her residence for the purposes of inflicting bodily injury and or to terrorize the victim, also a first-degree crime. How does your client wish to plead to those charges?
Your Honor, at this stage, we would enter a plea of not guilty.
And the penalties, or the highest penalty for the first-degree crime is life without parole. All right, you are here on your first appearance on these charges, Mr. McCaffrey, so I'm going to explain your rights to you. You have the right to remain silent. Any statement you make may be used against you. You have been approved for the Public Defender's Office to represent you, and you'll be assigned to an attorney through that office. If you are not a U.S. citizen, there may be negative consequences to pleading guilty or if you're convicted. You have the right to a detention hearing. At that hearing, the state must establish probable cause that you have committed the alleged offenses. You have the right to an attorney to represent you at that hearing, and again, you have been approved for the Public Defender. You've been charged with indictable offenses, so you have the right to a probable cause hearing and the right to have your case reviewed by the grand jury. If the grand jury returns an indictment, you will have the right to a trial by jury. You also have the right to waive a jury trial and have your case decided by a judge on what we call a bench trial. Do you understand your rights?
Yes,
Do you have any questions?
I do not.
What is the state's position as to detention at this time, Mr. Murdaugh?
Judge, based on the public safety assessment and obviously based on the nature of the charges here, the state has filed a motion for pretrial detention.
Okay, so based on the filing of that motion, the defendant will remain detained pending the detention hearing. We were going to schedule that for Monday morning, if that works for council.
Yes, Your Honor.
That's fine. Thank you, Judge.
So we'll come back on Monday morning at 9 o'clock in person here at the courthouse. We'll do an OTP for Mr. McCaffrey to be present in person on Monday at 9 a.m. And that'll be for the detention hearing. Is there anything else to address?
Does Your Honor want to give out a possible pre-indictment conference date?
Why don't we list it for May 18th?
Okay.
Jeez. Next year?
Depending on where we are, but until May 18th, that's for the pre-indictment conference. All right, anything else?
No, Judge, thank you.
All right, the matter is concluded.
That's it. That's it. Creatures of habit. Creatures of habit. So I learned about this because the wife, right? The new wife, who was the Citadel employee, became missing out of the blue. And, you know, it was all over the news. And later on, they caught him in North Carolina. He was living with his wife in South Carolina. And they took him back for a 1990 murder of Lisa Marie in New Jersey, in Suffolk County. So, you know, his wife has been missing in South Carolina since March 17th, 2012. 36-year-old. She just vanished. She, you know, in an area that is not a bad area. She vanished. She just disappeared. One day she's missing. So what it's been out on the news is that Robert McCaffrey claimed that they had an argument, right? They went for a drive, and he went for a drive, like he got out of the house and went for a drive, and he found like a letter from her to him. But then it's been reported that investigators took a deep analysis into this letter and that he fabricated that note. So, wait, I'm going to show you. Okay, wait, let me see if I can show you this. Okay, wait. Wait, okay, I can't. Why can't I? I hate it when they tell me that I can't. So, hold on. Or when I think I can't. I think I can. I know I can't. Let's see. Okay, here we go. Let's see if I can.
extradition, will now be sent back to New Jersey to face murder, kidnapping, and burglary charges in a case that went cold for decades. Since 1990, technology has changed. That was when Lisa McBride was murdered. Well, we've now learned that investigators used DNA found back then to match with DNA found here in the Low Country after his wife, on the right here, Gail McCaffrey, went missing.
And tonight, News 4's Webb Wright is digging into the arrest warrant out of Dare County, North Carolina. And Webb, we've got a lot of layers, new details unfolding.
That's right. Court documents obtained from Sussex County not only show a timeline of events surrounding the murder of Lisa McBride, but also paint a chilling profile of the man charged with her death, Robert McCaffrey Jr. And the biggest bombshell, that McCaffrey may have confessed to the killing all the way back in 1995.
Wow. This is
DNA evidence
ridiculous.
from what prosecutors called a particular item of evidence found on the headboard of Lisa McBride's bed, combined with a DNA sample from Robert McCaffrey after his 2014 arrest on obstruction of justice charges related to the disappearance of his wife, Gail, in 2012 here in Charleston, playing a huge part in his arrest last week in connection with the murder of McBride.
All these years I've been waiting and waiting and waiting, wondering, saying, you know, with DNA and all this stuff, they've got to, why can't they do something for Lisa?
Former Charleston County Sheriff Al Cannon, who was leading the sheriff's office at the time of Gail's disappearance, said McCaffrey's arrest could have impacts on Gail's case here.
When, you know, this case evolves, we'll see, you know, whether or not we're going to be able to get any assistance in locating her remains.
During the initial investigation in New Jersey, law enforcement cited multiple suspicious circumstances at McBride's home, including a wood log placed under a rear window, the screen of that window cut open, cut telephone wires, and McBride's bed stripped of sheets and blankets. McBride's remains were found in October of 1990 by a local hunter.
They found her. They had a massive search going on. We were happy at first, thinking, oh, good, they found her. But then we realized that it can't be anything positive. And they told us that they had found the body over at Walpack.
Court documents producing two bombshells. First, prosecutors interviewed someone they described as an associate of McCaffrey, claiming McCaffrey confessed to him in 1995 that he murdered McBride because she would not go out with him. Though investigators said the family of McBride told them she did not know McCaffrey. And his military record. McCaffrey joined the U.S. Navy in July of 1989, but...
Here we go. See, this pisses me off.
Two psychological evaluations in July and August of that year determined McCaffrey was, quote, unfit for service due to, quote, impulse control issues, and diagnosed him with borderline personality disorder. And he was dishonorably discharged in September of that.
Did you hear that? So there were two background checks and two assessments, two psychological medical assessments done on this guy, which caused his dishonorable discharge from the Navy. So when that happens, okay, so you discharge him, and what do? You throw him back into what? Into society? Do you recommend him that he continues to, he's got to be monitored, that he's got to be something? Do you do anything with this kind of people? If those assessments are only done and performed for one purpose, and once you identify they're unfit for a personality disorder, nonetheless, do you alert anybody? Do you do anything? Do you, oh my God. So what you're saying is that had you done something, this could have been avoided.
That year. Now, according to a complaint from New Jersey state officials, Robert McCaffrey Jr. moved from New Jersey to South Carolina in 1996.
Of course he did.
The complaint said he moved with his family members, but doesn't specify who. A year later, McCaffrey married Gail Broom. Working for you, Webb Wright, News 4.
And now she's missing too. And now she's missing too. She's freaking missing too. And I'm probably, she's dead. She's dead. Like, look at the picture in the middle here. This is a younger version of him. You know, I mean, at a simple look, any single one of us can look normal, right? because we look like normal people. But if there is an evaluation because you're trying to join the Navy and they determine that you have a multiple personality disorder and obsessive and whatever behavior, they should not just throw you back into society. Because what happened was, if somebody tells you they don't want to date you, they don't want to go out with you, what happened is just what happened. So now we have a cold case since 1990 of somebody who was murdered because they didn't want to go out with you. Those are the social illnesses and problems that we have in our society, that even though they did a background check and an assessment, a medical assessment twice, in less than a year, they did twice, 2 assessments on this guy, it doesn't help us if you don't see it through. You got to see it full circle. It's not enough that those evaluations cause you guys to make a decision to discharge him, right? Because he wasn't fit. If he wasn't fit to serve in the Navy, he's not necessarily fit to be thrown loose, wild and free into society. Because when they do, what happens is what we are looking at right now. A 1990 murder cold case in New Jersey. Murder somebody because they didn't want to go out with them. And that's what pisses me off. I'm going to follow this case. I think I'm going to have to find this lady. I don't know that she is. If anybody stumbles into her on YouTube, please let me know. But I'm going to try to follow her because I need to know what happens here. And the other case, you know, they haven't said whether they're going to link him to him, but that letter that apparently she left behind as a farewell letter was written by him. So it's like creatures of habits. If they're uncaught, they're going to do it again. And that's the same situation that we are seeing where? In Norfolk County, Massachusetts. So just wait. This is going to get so much better. These people, all of these people, every single one of these criminals who think that they have been getting away with this for years and years and years, little by little, we're going to catch you. You're going to get caught because there's no such thing as truth not coming out. Slowly but surely, the truth is going to come out, just like it is in the Karen Reed and John O'Keefe's case. I'm going to follow this case just because it interests me. I'm not sure whether I'm going to be able to dedicate time to it, covering it among, the auditing and everything else. But it certainly calls my attention. This is something that could have been prevented, especially with the second wife. So, and the first wife, because the Navy already knew that he was unfit for service, and they knew the reasons why he was unfit for service. So, we got to do a little bit more. We cannot just, okay, yeah, no, bye, no, yeah, nah, no. We have to be able to hold ourselves accountable too and do more, especially when you're in positions that you have the authority to do more to protect the public. There's this half-assing crap. I'm pretty tired of it. Either you want to be in jobs that make a difference or just quit. Let other people do the jobs. Let other people be in positions of authority that can safeguard the public and society and our kids, their children, the children of our children. Oh, this pisses me off. But anywho, I'm going to take a break. So I'll be back. We're going to talk about Celebrate because I found out a couple of other things and I want to talk about that. And I'll probably be back. Thank you all.